So can we start?
Yeah, please go ahead, Pooja. Yes.
Aarti?
Yes, ma'am.
Please start with the introduction.
A very pleasant morning to intellectuals, honorable guests, and respected teachers. On behalf of KLE Societies, KLE College of Law, Navi Mumbai, myself, Aarti Nevse, welcome you all. The theme for the series is Women Empowerment, and it is exclusively dedicated to women speakers. I will be hosting today's session along with Professor Pooja Bijjargi ma'am, who will be moderating the event. Our guest speaker for today is Advocate Kamiya Jadhav ma'am. Ma'am, we welcome you all. Today, ma'am is going to enlighten us on the topic and overview of POCSO Act and Juvenile Justice Act 2015. Now, I request our principal sir, Professor Dinkar Gitte sir, to address our guest and our participants. Over to you, sir.
Thank you. A very good morning to all. A very warm welcome to our guest speaker, Advocate Kamiya Jadhav. Both of us share the alumnus. Both of us are alumnus of DS Law College, that is a Ferguson Law College, and I will bring it on record to say that she was very intelligent. She was a good debater and used to participate in a lot of discussions during college days. And here we are. I mean, I'm very fortunate to have you, madam, as an panelist on a webinar series of ours. And we welcome you. I welcome you on behalf of KLE Societies, KLE College of Law, Kalamboli to this event. I'm also very much thankful to our management, Shri Prabhakar Koreji, Dr. Prabhakar Koreji, who is the chairman of KLE Society, Shri Mahantesh Kavadgimatsa, who is the GB chairman of KLE College of Law, Kalamboli, and also a chief whip of Government of Karnataka, MLC, Government of Karnataka. I am also thankful to Dr. Mallikarjunaya, who is our mentor, Principal KLE Law College, Bangalore, all the participants, my team, all the professors, and all the student conveners. Without wasting much of time, I think I should hand over this session to Pooja Bijjargi. Over to you, Pooja.
Thank you so much, Principal Sir. Thank you. With immense pleasure, I would like to introduce the guest speaker for today, Advocate Kamiya Jadhav Madam. Madam is an eminent lawyer, successfully practicing in the fields of civil and criminal matters all over India. Madam has studied in Barnes School, Nashik. She completed her law degree from Ferguson Law College, Pune, and further pursued her business law from Symbiosis International Law College, Pune. Madam has practiced and worked in 156 courts all over India, as well as practiced as a defense lawyer in CBI and CID, Mumbai, since 2009. Madam has to her credit books and articles on child abuse and orphan child, and various other articles on women empowerment and their legal rights. She has articles published in the magazines of Flair Talk magazine and India Today magazine. Madam is the first lady lawyer to appear in the courts of America in the year 2017. Madam has received and is tagged as youngest successful eminent lawyer from Nashik. She has received 11 awards on the row. She is an International Bar Member Association. Sorry, I apologize. She is an International Bar Association member, whereas she has been to conferences all around the globe about media and juvenile crime. Madam is also called on panel for subjects on women empowerment, child abuse and victimization. Madam has to her first canvas painting exhibition on 14th June 2014 by the hands of Police Commissioner of Nashik and later by District Judge Nashik in 2017. The paintings depicted about the woman and her powers. Also, the credit and money out of this exhibition was given to the rape victims of Nashik for their medical services on such victims by maintaining the confidentiality. A very thank you, ma'am, for accepting our invitation. And we are fortunate to have such an experienced person as a speaker. And I'm sure the participants would enjoy the session. Over to you, ma'am.
Thank you.
Ma'am, you can start with the session.
First of all, good morning. And It's actually an immense pleasure and incredible honor to be on this platform. Just a minute, I still can't get my. So it is an incredible honor and a pleasure to be a part of this platform. First of all, I would really want to thank Professor Dinkar Gite, sir. I should call you sir now, okay? And Pooja ma'am, who actually is the main coordinator for all this. And very soft spoken and cordially, she coordinated that, ma'am, when can we have, and we want to invite you, and the process where I'm really absolutely I feel really obliged that, okay, I can be a part of this kind of a new university where we can spend awareness about certain topics which are delicate in the society, which is unfortunate for people like for the Indian society. It is an unfortunate, but this act is important. So before we start with this act, I'll be, as I have taken up a topic on to talk about POCSO, which is honestly very close to me. The reason is because, as I would just give a little briefing that why I got close to this POCSO Act, and as well as JJ Act, and about women empowerment, is because before I started my law, I was working for an NGO when I was in Helena's for 2 years in Pune, where I did my schooling. I was working with Edinburgh, which is an NGO. And through that, we realized that we as children would go to the orphanage, would go to the old age homes to celebrate Christmas, Diwali. These kind of, arrangements were done by the school. And that was a thing which I realized when I was in my 10th grade, that this is something that we need to, do it personally. We need to give it personally to the society. So apart from that, when I came into law, and I was studying in Ferguson. From there, when I came back to my native, I'm practicing in Nasik District Court. I realized that I need to figure it out again, the old age homes and the orphan, the remand homes. So my personal attachment was too much before I started practicing, was visiting the remand homes. And I realized that, okay, there was a corporator, there was a special judge, magistrate, which was put up for the remand home children. And apart from that, how the process happened, and what was the mentality, the psychology of the children. So this was my personal experience, where I just by out of track wanted to go visit that way. And once when I started practicing since 2009, obviously I was very sure about getting into criminal law itself. So meanwhile, then there were matters coming up of POCSO. And that was the main reason why I chose this, because this is a very delicate law act, and it is necessary. But at times, not at times, it always feels that, yes, it is unfortunate for us to also realize that this is made a very strict law, and the process has changed, the charges, the issues, and the way the environment is given to the child. So before we start with the POCSO, I would just read out a little poem which I have published, and which was selected by the Penguin Publishers UK. And it's a piece of just 4 or 5 lines that would say that, I do want to speak up, mother, but I am frightened. Now, honking of the car also frightens me. The doorknobs also makes me feel someone there watching me. Will you believe me, mother? I have not done anything wrong. It's not my fault, and it's not my fault. So this was a piece of poem which was published in the first publication of my book named as Angels in Hell. where you talk about the types of abuse, that let it be sexual, emotional, physical assaults. It talks about the stories that I came across when I was supporting and helping the ashrams, the orphanage homes. So this is a piece of writing which was given across regarding the scenario in the society for the children. So when we come about POCSO, now the POCSO talks about the Protection of Children from Sexual Offences Act 2012. Now, in 2012, when this act came into process, after that, it was again introduced in Rajya Sabha in the month of 1st of July 2018, and again it was passed. It was introduced and it was passed on 24th of July 2019, where it came to a picture that the minors should be handled with care when they have been put forth for the process before the court, before the trial, sorry, for the trial, before the court, any evidence, any statement, entire thing, the process, if there is a minor involved. So the colors of the court changes. I mean to say is that as we talk about this act since 2019, which was amended, which was made more strict. So getting back to 2012 and then later on 2019, when it was amended, it almost mentioned about how the imprisonment and how the punishment would be. So first of all, when a child is a minor and he seeks for a complaint or anything of that sort, so the statements or the complaint, it's not necessary that the child or the minor needs to be in the police station or needs to go to the police station. There would be the officers coming at home or wherever the child is comfortable. Secondly, the child needs to be in a guardian along with a guardian, but not necessary that the guardian should be a natural guardian. So we need to understand that this act has been so beautifully put up for the minors that the minor, whoever the minor, the victim, has trust and is being comfortable, can go ahead. The guardian can stay with the minor to give the statements for the trial and things so ever. So apart from this, a special court is being appointed in the places like district courts. If there are no special designated courts, then obviously appointment of a sessions court looks into this matter, where in-camera proceedings are done. So what are we talking about? The in-camera proceeding is such that the police officer, first of all, who takes the statement or anything talking to the child regarding elaborating the offense or the scenario and the situation what this child was, the police officer does not need to, should not be in a uniform. He should absolutely be into civil uniform, and the officer should be a lady officer. So the things starts when the guardian or the child is about to give a complaint to the police station. And once when the complaint is lodged, it's been reported to the police station, then the police machinery have to inform it to the CWC, that is a Child Welfare Committee, which would take care of the protection, security, and everything of the child. Now, once when the statements, when the FIR is proceeded till the charge sheet, in this process, it's very different compared to the criminal practice of law we have. This entire process is in cameras, as I told you before, and apart from this, the bail matters, what as different defense attorneys go through, they are not acceptable. Because when the judge itself sees that POCSO, forget the sections, the POCSO is involved, then they would be like, no, we cannot pass you for anticipatory bail, even though the accused has a right for it under section 438, anticipatory 439. But still, unless and until the child, the minor statement or the guardian statement is not being taken, the court would not pass such orders of immediately granting bail or maybe releasing from the custody. Now, apart from this, what I would like to add is that the main thing that I have realized when working for minors is the psychology that is important. So the police officer, if in need, can obviously go for a psychiatrist or a psychologist or maybe a counselor also to maybe to talk to the victim at the time, and then to understand that how would they put up the report and how would the maximum information the police machinery can get it on paper, that is the FIR, because that's the base system. It's for criminal lawyers, we could say that the FIR is, the way the doctors say that our patient is important than the medication. So the same way for us, the procedure, more than the procedure, the FIR is more important for us as criminal attorneys. So when we look at the FIR, it is the whole sole duty of the IO, the police machinery, to get the maximum information possible, get the maximum witnesses possible for the trial. And the minor, the victim, is they need to finish up their evidence within 30 days of the statement. Now, 30 days, that doesn't mean that every day the minor is going to the court. No, it is the statement of the minor to finish up the trial. So the special court has the inherent power, and it is being given in the act that within 30 days you need to complete the statement of the victim. And the victim should not be called again and again. And the victim should be given this kind of an environment where the lawyer itself cannot that this is the only act where you cannot cross-examine the minor, which also directs that this law, this act is so severe, and there might be a certain kind of society who would say that this is absolutely biased, but no, this would not be called as bias, because once a minor being involved, who is vulnerable, whose intellectuals is very low, and who at times doesn't even understand the offense has taken place. So for such thing, this is something that the court would look at the gravity of the offense. And when we talk about such things, yeah, just a minute, I'm just getting a can't see it. Okay. So when we talk about such gravity of offense, which is actually required in the society, we come across that the judiciary takes this very differently. There would be judges who would, I would want to just put up my experience. There was an case, it was not POCSO, it was Guardians in Wards Act. And the husband was staying in Faridabad and the wife in Nasik. And the child was like 6.5 years old, and she was residing with her mother in Nasik at her maternal place, and the husband was in Faridabad, and he had filed a Guardians and Wards Act application before the Sessions Court, before Honorable Judge Bhattad Sahab. And the case was pending there for 3 years. And the status, what the mother would get it only through the e-courts, that the case is pending and there's an order. But the reason she was worried is that he shouldn't get any order from the court that the custody should be given to of the girl to the father. So I appeared in Faridabad court, and looking at the scenario of the courtroom and the judge, I realized that this application should not be entertained here as per section 7/11, because the jurisdiction of the guardians and wards application lies only where the child resides. So thankfully, on the very first and the last date, I applied for that application. I submitted that application, and I argued the matter. And meanwhile, in that period, the judge also realized that the girl and the mother, obviously she was separated, but the mother was not interested. The girl was not interested to go back because there were few things where she was not comfortable with her own father. And after that, immediately the matter was disposed of. It was rejected of the petitioner. And when I returned, that time I realized after the rejection of the matter from the petitioner there, when I came back and I again met the small girl, and then she told me that my father used to be too abusive. So over here, we are just not talking about sexual assault. We are just not, because the offenses which take place for the minor, it is emotional. It is something that is lifelong. So the so-called girl who obviously got the order, on behalf of her of not going to her father, but for the rest of the life, she would have somewhere in her mind that, okay, that fearful period where, my mother is worried, and do I have to go back to my father? I don't want to stay there, and my mother is because to these vulnerable, beautiful angels, we cannot teach them law. We cannot tell them that what are your rights at that age. To know the rights also, as per our Indian judiciary, you need to be 18 plus. But obviously the minors do have rights, but they themselves do not know it. That is what I mean. So when it comes to a picture about minors, it is just not sexual assault. It's not, even it comes as about POCSO, we talk about sexual assault, we talk about pornography, and we talk about, things where the offense which takes place. If you're talking about offense, then the offense might come into a large picture. That would be offense of touching, offense of maybe provocating, maybe showing something, some video, some picture, anything in the custody that would fail to have that attitude towards the minor of doing an offense, which matters a lot. And for this reason, the POCSO Act itself talks about that there are certain measures that we need to take as citizens, as a society, police machineries, the special courts, the CWC, that's the Child Welfare Committee. Then you talk about the witnesses involved. There are witnesses when they get hostile. There are witnesses, the child itself at times has different statements. For example, like when the minor is before the police machinery giving statement, that is section 161, and when the minor is giving a statement before the magistrate of the special court, that is section 164. So most of the time it has seen that the 161 statement and 164 statement before the court has differed. So what happens here in this scenario as well, as defense lawyers, it might be a chunk of this thing for them, but still the court looks into the gravity. That's the best part of the POCSO, that even though the statements differ from to the police machinery, to the statements given to before the magistrate, even in the trial, when the statements of the witness uh, of the minor, the guardian, and there would be statements by the guardian only, and if not the child, the statements of the medical expert. Even though if in certain cases, if medical expert is not available, the gravity of POCSO still remains the same. So, as defense lawyers, when we have to think about it, we have to already give out 90%, that 90% of the entire this is on as it's POCSO. So we just have about 10% to defend if we talk about defense attorneys. So if you talk about the period, the trial which goes ahead, as I told you before, that it should be 30 days before, if within 30 days the statement on the victim the evidence of the victim should be completed, not above that, and the entire trial should be completed within 1 year of the case, the entire proceeding, withhold with the charge sheet and every charge sheet, witnesses, and the entire process in the before the honorable court. Now, in this, what I would like to, as we have more of our students, I would like to put forth that how and how and when can we as defense lawyers see over here. I'll be explaining it from the complainants, that's a special prosecution side as well, and as well from the defense. In this process, you need to understand that the accused also has its rights. All right. So if the accused is in a position where he's not being left anywhere, that is the play of the Indian judiciary that I would say. As if you have ever noticed that in the courts you have these backed mirrors or a curtain where a box of asylum, no, sorry, not an asylum, but a box which is backed mirror. The backed mirror, in the sense you can see what the person standing inside can see out, but the person standing out cannot see who's inside standing or what is the object inside. These are the backed mirror which are placed in the special courts. And the reason why this is that the minor should not be in a vigilant to the accused. She or he should not be, I mean, they should not be able to see the accused in any which manner. But the accused has a right to listen, to have the proceeding before him. And so he is hidden, in short. So this thing also plays a big role, as the minors are vulnerable, and if because already they are going through a lot of fear, anxiety, and they don't understand that how do we proceed. I mean, they don't know what to do. We as adults would tell them that how would you what you need to do, and the questions asked, and so by the time the complaint comes to the police and the police statement comes before the court, the FIR, there is a little backlog where it does keeps juggling in between, where the police officer, the lady police officer, manages to get maximum information from the minor, the victim. And apart from this, as we get into talking about, first of all, I'll just finish up a little course on as lawyers, as defense lawyers, that what would be the defense for this, which mostly won't work, trust me, because the courts are strict. The special courts have their own provisions and the inherent power of the court, which when required, they could take it. So mostly the defense in POCSO that the attorneys would go for, it would be the delay in lodging the FIR. So I'm sure if any lawyers here, we mostly have this ground for our anticipatory bail, and even though in the regular bails we have our ground subjectively stating that the FIR was delayed, so the burden of proof lies on the victim to understand and this thing. But if you talk about this with satisfactory explanation to delay, the prosecution's case still cannot be discarded, even though there's a satisfactory shown by the defense before the court that it's been so still it would be in such a position that the court would still look at the victim, the statements, the information by the IO, and the delay in FIR would not be taken that in that serious manner, even though if it has a favorable, commission delay, and it has a favorable explanation by the defense lawyer. Now, if you talk about the second that I would do this is about the age determination. So in the crime where first of all the age is to be defined and things like that. Initially, there was a thing where the counselor would ask, maybe there would be a birth certificate, a school living certificate, and things like that. But now, if you talk about as through the medical experts and medical counselors that who, on a very quick note, go through this. So we have this test which talks about, I just on that page. Okay, so that test which talks about is the ossification test. I was in a thing of ossification test is a test which is obviously done by a medical expert, and the medical expert also needs to be a female when she does that, especially when the minor is when the victim is in that injury. And this test talks about the age. So initially there was there used to be an issue whether this age is whether this age is does come into minor. Then the defense attorney would say that no, this does not come into POCSO, this comes into some other this thing, as the POCSO has a retardability of only age of 12 and etc. But the legislature has made it very clear that over here, if there is a doubt regarding the age or anything, so certain medical experts would go for an ossification of this test and immediately get it confirmed the age of it. Now, this test has also been added in POCSO, where the process would fasten, because this would come into a fast track court. So the next that we could go ahead is the bail that we can go for. If the accused needs to go for a bail, he would obviously, if it's an anticipatory, then it would be in 438 before the sessions court. And if it's 430, if it's a regular, that is from the police custody to the magistral custody, and he's imprisoned, then he can go for a regular bail. But in that period also, almost 90% of the time, it is realized that he goes for conviction, and there is no loophole left. And this act, as we talk about, if we go before the court of law as an adult, we have judge, we have opponent, we have our lawyers, we have the opponent's lawyers that way. But in this particular act, we have everybody experts, everybody. Let it be, we have special court, we have guardian whose testimony is important, the victim's testimony is important, the IO's testimony is important, and they are very well prepared for this kind of a case which would be entertained before the court, as well as the accused is also being kept away about this. And I mean, obviously he's been informed, he's been shown or everything, but most of the time the recording of the child testimony happens to be just before the judge and the special prosecutor, who makes it a point that the judge is getting the maximum information and to understand that whether the conviction is possible in that matter. Now, if we talk about like a recent case where the minor was offended, and a lady police officer had actually, taken the statements. The FIR was lodged under POCSO, and then it was taken before the special court. The statements before the court, when the evidence was going on, till the FIR, to the statement before the court, everything differed. The reason was the minor was so vulnerable, and she didn't understand that why am I here, and why am I being called here again and again, and why does this lady gives me chocolates and she sits in a big chair and then she tells me, the kind of environment which is given to the child. And it was realized later in the conversation between the honorable court and the special prosecution and the minor with her guardian. And the guardian suddenly gets up and says that, Auntie, can I show you what happened? I have my doll in the car. And the guardian was a little surprised, who was with the minor victim. And the honorable judge was like, all right, we need to do this. There's something that she's trying to give us information, not through how we want it, but some other way it's coming out. And there was a proceeding that she literally showcased the picture, the entire thing, as if she was asking for a prop, because she couldn't explain what it was. So she asked for a doll. And when a doll was given to her, that time she showed the position, she showed everything that, this is how the ex-person did to me. And in that proceeding, when she was giving the statement before the honorable court, at that time, there was a realization, and it came to a conclusion that she had got a severe scratch on her private part, which was actually missed out. And she had approached her mother also, but as her mother was not with her, she already was into separation and divorced, and then she got married to the second person. So the guardian, who was a neighbor, she was there for testimony. So the thing what we're talking here is that even though this is a serious offense, the act talks about the laws, the ingredients that we need to fit into for the conviction or the acquittal. But in this, this is the only act, as my personal opinion, that there the judiciary takes it very seriously. If you ask my personal opinion, if you talk about the other acts, this act in which you can actually realize that the blood of the judge is also boiling when it says about POCSO. The IO is also in a such a position of directly just give a conviction and just finish it up that way. So when this, and this is the reason why this process is important. As as I told you, the minor initially was not that informative then before she came for 164, and after that before the special court, when she came and when she dwelled into that environment, then she realized that okay, now I can speak up and now I can say nobody's going to harm me, because most of the time the minor and the family, they themselves start blaming themselves, you know, that oh, it's a shame, it's an for family or honor, then it's there's a fear, there's anxiety, and then now what are we going to do and things like that. So somewhere I feel that obviously the child counselor is available and they are there in POCSO. But somewhere I feel that the counseling of the parents is also important in this matter, because in the end, the child is with the guardian 24/7. Even though the child is going for a counselor, that would be hardly for not more than 45 minutes. So the person who is taking care of the minor, no matter it's a natural guardian or guardian by the appointed by the court, whosoever, he also needs to go through a counseling so that the and a understanding that he is in a possession with a minor and how he needs to deal with it. That's also an important part. So when we after this come into regarding the compensation that I would talk about. Compensation is obviously given to the victim, and the compensation is from the state government, inclusive of everything. That is the medical, the loss, the injury. You talk about from even though if the minor is traveling to the entire amount of the compensation amount is being paid to the victim. So that way, judiciary nowhere is into a picture where you we cannot do this for you. In fact, it's actually been welcomed very openly by the special courts. And one thing I have realized from my experience, I've come across, and I have appeared for almost like nine matters in POCSO as a defense lawyer, not as a prosecutor. But I have realized one thing, that it is rightfully said that if this POCSO law would be biased. Now, in one of my matters where as a defense lawyer, the defense was theory of alibi, and as well as the mother, the husband, wife, and the husband don't used to stay in Nasik, the city itself, and he used to travel 1/4 from Pune to Nasik. And there was a scenario where the girl was only 12, and she was caught red-handed with some other individual in a very bad scenario, and the girl child was in the hall living room, and the mother, the wife, was with some other man when the husband was not in town. And when all of a sudden, when the husband came and he caught her with all this thing, and he directly made a decision of leaving her. So the mother tried to strangle him into POCSO, and before he could leave the house or take any decision, And after discussing this with her relatives and things like that, she went to the nearest police station, and after 8 days she filed an FIR against her husband, stating that my husband came and he sexually assaulted my own daughter, I mean his own daughter. And this was the picture which was completely behind the scene, and what was coming before us was only the FIR and the POCSO sections, and the sexual assault, and the statement which was told to the victim to talk like this to the IO, to the lady constable. So, and we already had the evidence that he was not here, and when he caught her, he already had phone recordings to one of the middle relative, where he had mentioned that I have completely caught her with all this, and all the relatives, please kindly come home, and I really want to dissolve this marriage immediately. And she didn't wanted that, and she wanted to entangle him in some or the other way. And it took like it went for mediation between the families itself, and after 8 days, to catch hold of the husband and to teach him a lesson, she went for a false and fabricated case, and filed a POCSO case at Nasik jurisdiction. And in that, the evidence that we had, it was quite clear that we would go for, obviously, for a bail, but the evidence that we had was, there was nothing that the lady could prove, or anything of that sort, because the evidence, whatever we had from the accused, was very clear. And he had the receipts, the tickets to everything, the call records, and minute by minute, everything was, taken into consideration. But even though, as this was a false and fabricated case, the matter was put before the Sessions Court for anticipatory bail, and a special prosecution was, appearing on this. And I remember just one thing that the judge told me, that I do see that, your the merits from your side, the weightage is more. But somewhere I have a grudge that if I pass this order, there would be a wrong message gone to the society. And till today, I realized that even though the bail was rejected, and yes, of course, the accused had to go through a lot, because he wanted to dissolve the marriage and things like that. And the lady had put up fabricated case, and it was bad from his part. Somewhere I realized that this POCSO Act, which when it plays in the special courts, they also take care, the judiciary also takes care that what are you serving to the society. So when you realize that, there are judgments passed by the honorable courts, which also takes care of what would they show to the society. And that was the time, like I had this matter like almost like 6 years back, and that was the time I realized that yes, it's just not about the evidence, it's just not about the bail, the procedure before the court. It's also about what are we giving back to the society, even though the system is in the society, for the society. So there was a realization, and then we had to tell the accused to get himself surrendered. He did surrender immediately, and he absolutely gave all the went through a proper interrogation, everything on a very proper, because he was a well-known person, and in education wise also he was very settled about those things. And he said, he just told me that, ma'am, if this is how it is, I would surrender, I would go before, and if I am being put up framed into this, let me go through it. So, because the act was also told him, explained to him by us that this is how it's going to happen, and the agony and the harassment and everything. And he had to surrender. He went through interrogation, evidence, the trial, everything. Later on, he was released on regular bail when there were not much of evidence put forth. So the thing what I'm trying to put up here with all this is that, you know, every coin has its own side. That's why defense lawyers are also born, and prosecutes are also born, because if there's a law. I would not completely 100% go through the law, honestly, because as we say that the the disadvantage, the misuse of the law has also taken place in this POCSO Act, and the victim, the not the victim, the minors. I can't say victim here, but the minors have been used, manipulated, taken disadvantage of just by the adults or the guardians staying, so that they can fulfill their own constrainment. So for that matter, this special court, it plays a very big role. So when you come about the testimony of the child, you talk about the right of the child, the legal aid, which is also free to the child, which is obviously anytime, even the CWC goes ahead. Then there is a protection also given to the witnesses in the entire trial as well. If the witness goes hostile, still it doesn't matter, because the gravity for that special court remains the same. So I have tried that as well, where the witness feels that she or he needs to go hostile and things like that. So over here, I am talking about the experience, what I have gone through before the court, and how it is being dealt, of course, as a defense attorney. And it is very important that this kind of an act, which is delicate, which is required, and if you talk about complete the solution for minors, which are towards sexual assault and things like that, this is absolutely a law, an act which would protect, which is protecting, and which is serving to such minors. And apart from this, as we talk about that, if a minor is a victim, and the offense is taking place at the same premises, or at the house, or in the family itself, and the minor, the neighbor, or if the minors, even in the school, for example, the student is going and talking to the teacher that, I've been I feel that so and so thing has happened, and the teacher realizes that this is an offense, which is happening, and it is happening in the household itself. So the teacher herself can go and report the complaint, and which is mandatory. Now, POCSO also talks about the mandatory reporting of the mandatory. Now, in this, to report the complaint is mandate. It's a mandate. As I told you, that if the teacher gets to know, and if she does not take certain steps of going and reporting it to the police station, or to the principal, or to any authority person, she would also be called as an accused, and there would be an imprisonment for 6 months for not reporting. So what are we talking here is about that, since so many the crime has taken place, but the reporting has also made it a mandate, which makes it a point that you need to report. And even though if you do not report, there would be there would be a complaint against you if you do not do that. So apart from this, as we talk about POCSO, now we come to 2019. So in this scenario, the amended law, which was obviously passed in through Lok Sabha in August 1st of August 2019, which also mentioned that the imprisonment and the death penalty would be given to the accused before if the minor is below 12. And if the minor is above 12, the imprisonment would be to 10 to 20 years of imprisonment. But all this, it comes up to the gravity of the case, the fact of the case, what has been put up before the court. And for that matter, how do we proceed, and what are we in return giving to the society? Now, as we talk about the JJ Act as well, it does not go hand in hand. As I'm here only to give you an overview, because I don't want to be a very bookish about this. So JJ Act is for the children who are in the remand homes, through who are the main, you can say, who are as an accused. And POCSO is the protection for the children for sexual assault. So there are a lot of presumptions in this, that, okay, does this work this way? And awareness to the society is necessary, because most of the time the family itself of the minor gets more affected. As I mentioned earlier, that not only the child, the minor needs counselor or a counseling. The guardian, the parents, the relatives of the children who are also affected by such offense do need counseling here. And apart from this, it all depends that how we take it before the court. I mean, how the prosecution takes it before the court and how they will deal with it. Now, as in this act, you cannot cross-examine the child. You need to put your questions before the court, and the court in its own manner would question the child. The accused would be hidden, but obviously has a right to know that what is happening, and how do we go about, what are the allegations put on him. And apart from this, the punishment has become rigorous. The punishment has become absolutely in such a manner that there's no loop which can actually, it's almost an absolute law which has taken place. So just excuse me for it. ये वो हो गया. I don't know.
Ma'am, is there any?
Am I audible? Because I could just get a.
Ma'am, you're audible.
You're just went this thing.
Ma'am, you're audible.
Okay. No. There is some this thing going on.
Ma'am, we can hear
notification.
you, as well as your video is also visible.
Okay. So apart from this, if we would go ahead, as I told you about, we spoke about delay of lodging an FIR, the age determination, the bail matters, the investigation, charge sheet, framing of charges, and the trial, recording of child's testimony. Recording of child's testimony would also be with a medical examiner, and with the IO, and the entire testimony, which would be under along with the guardian of the child. So the after that we have victims compensation, minors compensation that we would talk about, and then obviously protection of witnesses in the matter, which was will be taken care of by the IO and the CWC and the special court, of course, and presumption of guilt, and the mandate reporting in the POCSO Act. So this act is you can say small, but to the society, looking at the vast, because every case, every grounds of the case is different. So the kind of the court takes care of such acts is absolutely on more of the police machinery side, the victim side, and it is absolutely inherent power of the court that how would this go ahead. So I absolutely appreciate that as you have called me for this to talk about this topic, which is important, but somewhere I feel little saddened also, honestly, that that such beautiful angels, that when they are so vulnerable and they have to go through this, and we as the citizen and the society don't have any option but to keep trailing and just accept and go with the flow. So I understand, and we're still trying. I mean, as we're supporting an NGO as well, we're still trying that how much ever possible we can go ahead and help and give our absolute support, and try and make it in such a way that one fine day this law should not be needed. As this is makes it very difficult at times, even being an attorney and the lawyers also, to understand that how we would go ahead, and we just don't want that. I mean, that's my, whatever I am stating is my own personal this thing, apart from the court that we proceed and we work on. But when I get matters such as anticipatory bails and regular bails, and before the sessions court, even the judicial magistrate first class, the door of the practice is different when it comes to POCSO. So somewhere, even being an attorney, your heart does sink that way. And I would just try and put you before that please be aware in the society. Make it a point that if there is any such case, please report it. And instead of focusing on, on the crime or the offense which has taken place, before that, instead of the cure, why not to be precautive? So the precautions and all these things would come again through the parental and the guardian duties. So as we were on POCSO, I would just want to add one thing from my side, is the parental duties, that what are we giving our children? If we talk about our Indian culture and the history, the other night, I was just wondering, and I realized that there is no history about children. What we know in Hinduism is just about Bal, Krishna, Gopala. In Christian, we know as infant Jesus, and in Muslim, we would talk about Nana Rosara, who would, a small kid in the family, in the Muslim family, would do his first Rosa, and there would be a huge feast on that. And in Christianity, there is infant Jesus, and in Hinduism, there would be Lord Ganesha being a baby Ganesha Lord, and Bal Krishna and things like that. So apart from that, we in our Indian history we've had a lot of leaders, wars and warriors and queens and kings and killing, and then their inventions and inventory, go on. But nothing against children, because that is what the culture we come from, where children has always been taken up as pure. And in Hindu rituals also, if you talk about, we tell these small Kanya Kumari to those young girls to come home, to feed them, to do their puja and things like that. So it really upsets me somewhere that this is not where we belong to, and how does this society even accept about doing such offenses for the minors. And apart from this, it makes me a little sickening. This is important. I understand. I really apologize. This is important, but somewhere this is really sickening to understand that seriously this kind of offense does take place, and it really hampers a normal human being also to understand that what would be the output of this. Now the accused who do this or have done this are always in a picture that this won't come out. This won't be published orally or written, or there wouldn't be a complaint if it's been done to the offender. And but that is absolutely wrong, because now, as for if you talk about the courts, the special courts, the people now at this stage have become so aware that the offense, let it be anything, even their own mother and father are being rude or shrewd to the child, the neighbor and the other people who are aware, like teachers, whoever that minor gets in touch with, can obviously opt for this kind of an report, and on that it's become mandate. So I in short would just conclude everything stating that this was my overview on POCSO, where I have spoken about the defense from the attorney's side, and as well as the prosecution side, where we talk about both the sides and how this is dealt, the imprisonment and the other facts which come into. So it's my humble request to all of you, to even as students, actually honestly I can't see it here, but to the students, to the elder generation, to even my seniors if they are watching me, we need to put a hand in this act somewhere, at least something that we need to make this act more and more aware, no matter in simple terms, no matter that's the reason when I spoke to the coordinator Pooja ma'am, I told her very clearly that we're just going to have a general talk on POCSO, because if you talk about the bare acts and things like that, it might just get too heavy. So I just wanted to share my experience, and I just want and I request you all to please make an awareness about POCSO, and how the judiciary is being so so strict, and it should be. All right, it needs to be, but still, if you feel little pity about that, really, we as human who praise the Lord, who kneel before the goddesses, and we treat children as pure as Lord, it's something like you're creating or doing a crime to the gods that you're preaching to, or you're a devotee of. So for me, it is that. And I would appreciate and for this that if you could please pass on this and be aware of such acts. And uh, even though you being from different states, the way I usually do of going to the schools of telling students from third to fourth grade, fifth grade till ninth grade, to make them understand the adolescent, the child abuse, the parental duties. At times nowadays, the schools have this parental meeting. It's called PTM. It's a new thing that's parent uh, time meeting, something like that. And the schools have made this fashion of getting the lawyers or the counselors in the PTM time, so that the counselors could talk to the parents as well, that these are the parental duties, and how you could actually help to be precautive. Now in the parental duties that we talk about, again it would be you know make sure that your child is aware of bad touch, good touch. These are important. Plus, apart from bad touch, good touch, the second is about don't change clothes. Let it be father, mother, front of the child. If the child is 2 years old, 3 years old, so that he or she does not get into that habit. Okay, my the child is small, so I can, just do it in front of him or her. So these are the small minor things where the counselors do go and counsel the parents as well. So yes, I feel completely full-fledged about this act, and somewhere when I start talking about this act, as I've uh, been working with the orphanage ashrams and orphanage here, and obviously Edinburgh in Helena's, I somewhere feel little down to talk about it. So, Pooja, madam, can you please?
Ma'am. Yes, ma'am. Thank you so much, ma'am, for that insightful session. I can see continuously about 460, more than 460 participants being connected at the Zoom, as well as more than 100 on the YouTube. So the session.
Thank you so much. But I would appreciate that if there are any interactions or questions, because I'm really a little uh, honestly, about this act, I'm slightly emotional, because I think I work at the grassroots level, and there might be a thing that maybe I might have lost my track. But as since I was like 23, I was working with an NGO and looking at the children who've been abused, thrown out. There were children who were just born 4 hours and thrown under the bridge, and night 2 and 3 o'clock, me and the NGO people would run. So for me, I'm literally at a grassroots level where I have seen the abuse. Over here, yes, you might talk about the procedure in the court, the punishment to the accused, the compensation given to the victim, the minor, and things like that. But somewhere, I feel that children are not to be a part of this, and hopefully, I pray that someday this thing gets eradicated completely from our society.
Surely, surely, ma'am. We do pray and hope for the same. That is where we would like to make that awareness between the people, not only with the law students, but with the
Yes.
general people as well.
Yes.
Thank you so much, ma'am, for that session. Ma'am,
Thank you so much.
could we just take a few questions from the
Please, please, I'm waiting for those questions only.
Ma'am, the first question is from Mr. Rajneesh. He is asking, ma'am, could you please enlighten us what is the procedure when a minor boy is sexually harassed by any lady or any girl? He is further asking that, ma'am, could you even enlighten us on any landmark judgments which is relating to the sexual harassment of a minor boy?
Okay. Now, Mr. Rajneesh. Okay, I'll be giving you I have actually got like about almost 172 judgments, and I'll be giving that to Pooja madam, so that she can put forward for you, and which I have actually divided into. For example, if there are case laws in delay in lodging of the FIR, determination of victim's crime, the bail, why rejected and why this thing, investigation. So there are almost like 150 two case laws and judgments, which I'll share shortly with Pooja, so that you can and Pooja, please, you can also share it on your platform, where the students can actually go through the case laws and judgments for the same. And if you're talking about a minor boy, it's a very short this thing, that after 2019, initially it was just for the girl child, but the process will be the same, even though if it is a minor boy or a victim boy. So the process would be the same that I explained before, that it would be entertained before the special court by a lady constable, taking all the information, putting up before the court as per the FIR. And obviously the process, the trial would be the victim also within 30 days have to finish with the evidence, a statement of the victim, and within a year as per the fast track court. So in short, the process that we have for the girl child is the same for the boy child.
Thank you so much, ma'am. The next question is from our college student, Sumit. He's a second year LLB student. He's asking, ma'am, can a mentally retarded, that's a disabled child, come under the POCSO Act if her age is 18, is above 18, but she is mentally being the age of 7 or 8 years old?
Honestly, this can be entertained before the court, but there are the boundaries of the court as well. As in one of the case named in which was before the Supreme Court, and the woman was 40 years old, but her brain, her mentality, her age was just 7 to 8 years, and she was raped and assaulted and things like that, and she was absolutely mentally retarded. And even though the matter was put up before the court, it was entertained, and the same time the accused died. But the court couldn't entertain stating that it is POCSO, because the first ingredient, it talks about the age. So the court did pass on the compensation. So here, that is what I'm talking about. The court does have some inherent powers where they can not let the justice miscarriage. You understand? So this is the same case that you're talking about, is in the ERA's judgment, if you go through before the Supreme Court, and this was passed in 2017. Supreme Court, page number 104. I am slightly this thing with the numbers, but yes, this is it. And if you look at it, it was ERA versus the state, if you go through that case. So yes, POCSO is entertained in this matter, but the judge also has its boundaries, that he cannot do this, because the age factor is the one. So we are still lacking there, that if a mentally person whose age is 7 and 8, who comes into minor and still by age major. So yes, we are still lacking into it, but still there is a compensation, and it is still entertained for sure. Am I audible?
Yes, ma'am. Yes, ma'am. Thank you.
Yes,
So much,
I'm
ma'am.
done with the answer.
Yeah.
Okay.
The next question is from Mr. Kanak. He's asking, not every time the minor is a victim. Sometimes they are the convict too. What does the POCSO Act and its provisions say about it?
Yes, this is a very good question, and this is also, I want that to be aware, as I told you about in one of my own clients' case, where the child itself was involved in putting her own father behind the bars. For example, there was an article which also spoke about the child abuse, in which the girl was just 14, and she was on this some app named as Tinder, and she mentioned that she's 18 plus. And she did not and the boy with whom she was dating or talking whatever, she did not tell him that I am 18 plus or something like that, because the app itself through which you meet or maybe you conversate, it already stated that it was the person who would be handling this app would be 18 plus. So within this, it would be taken into as JJ Act for this kind of an for acquittal or any process regarding the children. So the JJ Act would be in effect of this. Am I?
Yes, ma'am. With continuation to that question, a next question is from a participant called as Preeti. She's asking, sometimes the accused child may also be a victim, as he might have committed the offense under some threat or under the influence of someone who is an adult person. In such a case, he becomes a child in need of care or and protection, and not a child in conflict with law. Will this child be dealt by the JJB, that's Juvenile Justice Board, or by the Child Welfare Committee?
I need to. Can you just repeat the initial line she said, please?
Yes, surely, ma'am. It says sometimes the accused child may also be a victim, as he might have committed the offense under some threat or by the influence of some adult person.
Mm-hmm.
In such a case, the child is a juvenile, a child under need of care and protection, and not a child in conflict with law. So this matter would be adjudged by the JJB or by the CWC.
This would be by the JJ Act, because over here the minor is an accused, right? That is what you mentioned earlier. So any of these would be under the JJ Act, because that would talk about the rehabilitation of the minor, the statement, the evidence, as well as how the special court takes the statement and how they trial before the court. So this would be absolutely before the JJ court, and as well as if there is any act inclusive of this, if you talk about CWC or maybe even they would be asked, because the court has the inherent power where and when, looking at the gravity of the case, to approach certain this thing, as if they are experts, if they are guardians or any which ways. That's in the end just to seek the justice. That is what we're here talking about. So it would go in JJ Act, I mean, as per my knowledge.
Thank you, ma'am. Thank you for that answer. The next question is from Suttapa Das. He is asking, does POCSO Act also deal with the psychological conditions of the child, like providing counseling sessions and all?
Yes, yes, of course. In fact, when the victim approaches the police station, and at the same time, the IO, the police officer, has the right to immediately call upon the counselor or the psychologist to examine at the same time. And in the same period, if they've been taking her for medical also, and the psychologist would be there, and when the matter is before the court, the psychologist also needs to put up his application that he was a part of this, and the IO also adds the counselor or the psychologist in this matter. So the role of the psychologist is from the initial. It all depends on the initial stage of the IO, how he is dealing with it, and if she feels, the lady constable, she feels, who is a rank of above PSI, feels that okay, there is a need of a psychologist, she can immediately opt for it free of cost to the victim that way.
Thank you so much, ma'am, for that answer. The next question is from Mrs. Shubhanjali. She is asking, what is the role of state government for protection of juvenile in conflict with law?
The role of state government over here is regarding the compensation that the state government provides. And when the victim is seeking for a compensation, and it comes into different subparts, like the medical examination, the travel expense, the psychologist counseling, in fact, the counseling from an expert. So all these things, and a huge amount of compensation which is provided to the victim, so that the victim would, depending on the gravity of the loss, what the victim has gone through. So for this, obviously, the state government is liable, and the state government pays the compensation.
The next question is from Bedabi Bhutipati. He is asking how to deal with an abuse on social media.
For social media, obviously, there would be the cyber crime. You have your own cyber crime unit in every. You can report it to the SP. You have your own cyber crime units in every jurisdiction. So if you could mail to them, or maybe put up an application, and then they would take care of it in the through social media.
Thank you so much, ma'am. Ma'am, with your permission, could we take up 2 more questions?
Yes, please.
Thank you so much, ma'am. Ma'am, I'm just trying to reframe the question from Mr. Sudarshana. He intends to ask, ma'am, what if in a situation or in a school basically where there is one staff who is having such a kind of mentality that he might do certain sexual offenses with a child. In that circumstances, how can the management take any action?
See, thank you so much for the question, because this question keeps arising again and again, and it is needed in the society. Nowadays, Pooja, if you understand, the schools have been given a gadget where they mandatory need to have a counselor for children. Where the counselors, if any child is not studying or maybe having any harassment or something like that, the school has their own child psychologist as well. So there is a point where the psychologist also meet the parents. And if such staff happens to get into such offense, then obviously the parents can inform to the principal, to the management, in that part. And apart from this, if that doesn't work, even the management, without the permission of the parents, can report this to the police. Because in the end, what really matters is the offense to the minor. Nothing else matters. You're going to the management, you're going to the college, you're going whatever. What really matters is the offense which has taken place to the minor. That's the only thing. So let it be being a complainant through a principal, college, parents, whoever, but it should be reported.
Thank you so much, ma'am, for that answer. The last question, ma'am, is from Advocate Mayur. He is asking, ma'am, is there any special child-friendly environment created for the for such establishments, or is it regular like a normal court?
No. The entire proceeding is taken in cameras, and in case if the child, if you look at into the family courts that we have here, we have those half of the family court is just a room where one honorable ad hoc judge is there, and the rest of the part is the garden where the children are playing and their parents are busy inside taking a divorce or taking a maintenance and things like that. So the judiciary is taking care of this regarding the children. Not only this process in POCSO, but when the matters are in the before the Sessions Court regarding Guardians and Wards Act as well. So a specific commission has been appointed, where the father can meet or the mother can meet with whomever the custody is, and the opponent can come and meet the children. For that matter, also the proper environment is being provided. There are gardens where the proceeding can take place. In fact, in POCSO itself, it mentions that there is no such strict subject that you need to do this in a quiet, dark, so-called XYZ room. They are free to, first of all, the first thing is to give that environment to the child, and then the proceeding would start in this matter.
Thank you so much, ma'am, for that answers. I am sure the participants have got enlightened. The way you spoke about ossification tests, that is not known to the particularly to the students, and the examples that you have quoted from your personal experience, that have given us a complete knowledge and overview. I would
Thank
say
you.
more than an overview to the subject. Thank you so much, ma'am, for taking your precious time and
Thank you so
having
much.
a session with us.
It's a pleasure, Pooja. It's absolutely a pleasure. And I just want to add here, I apologize if there has been a little mistrack of here and there, because if you ask me, I am part of POCSO if it comes where and when. But if you ask me to talk on my personal this is my weakest act, that which I feel that as humans we need to be not little more shameful about. So you could literally feel later on that I was literally draining and sinking in, because talking about the offense and sexual about the children, in the end we are humans. The judges are humans. The IO is a human. Me as an attorney is a human. So it drains out somewhere when we talk about, and it saddens you somewhere. And thank you so much for giving me this platform. And in the end, I would just leave saying this, that please keep make an awareness the first thing, and keep a mandate report, give an awareness to the society. And my entire this session was just about me, how much ever I could put up my moral and put up before about POCSO, that how important is this to the society. That's it. Thank you so much.
Thank you so much, ma'am. Thank you so much. Now I would request Aarti to propose the vote of thanks.
Yes, ma'am. It's my privilege to propose vote of thanks on behalf of this esteemed institution of KLE Society's KLE College of Law, Navi Mumbai, for this event. I extend a profound vote of thanks to Advocate Kamiya Jadhav ma'am, who, despite of her busy schedule, has found time to honor this session with her inspirational thoughts and educating all of us with such an informative session. Thank you so much, ma'am, for making this webinar very interesting. We all gained a lot from you today. I would also like to respect members of KLE management, Dr. Prabhakar Kore sir, Chairman of KLE Societies, Mr. Mohantesh Kavadgimat sir, Governing Body Chairman, KLE College of Law, MLC, and Chief with Government of Karnataka, Dr. Malika Arjuniya sir, KLE Law College, Bangalore, and Director, KLE Law Academy, Bangalore, and our respected Principal sir, Professor Dinkar Gitte sir, for their blessings and guidance. I also extend my vote of thanks to our hardworking teachers, Dr. Amrita Singh ma'am, Professor Pooja Bijirgi ma'am, Professor Sri Vidya ma'am, and Professor Muhammad Salim Khan sir for their enormous support and encouragement in all our efforts. I also mention my deepest sense of appreciation to student convener Apsara and Shara and our whole webinar team. Last but not the least, I value all participants and every moment they stay in this temple of learning. Once again, I thank each and every member from bottom of my heart for your cordial cooperation. Thank you.
Thank you so much, ma'am.
Thank you so much.
With this, we end up the session. Thank you.
All right. Thank you.